Okay, well, welcome everybody to our Lunch and Learn here today. It's super excited to be bringing this panel together on the H-1B, specifically the changing landscape. And for those of you that don't know me, my name is Jonathan Grode. I'm the managing partner of Green and Spiegels U.S. operations based in Philadelphia. I'm super honored to have my partner, Katelyn Karahan. She is here in the Philadelphia office with me as well. Katelyn is knee deep in the H-1B world. She sort of oversees that portfolio for the firm and has a very on the ground and hands-on type of experience with it, which I think is going to be really beneficial. Um, if you do have questions throughout the presentation, we'll do our measured best to answer them in real time. If you can use the Q&A function, there's a tab at the top of your screen that says Q&A. You can type them in there. I will be monitoring this. I mean, although there is only two of us here presenting, I'm going to serve as more of the moderator, so I will be responsible for that, but I will do my best to address questions because we are speaking about a very nuanced topic with the H-1B situation. If you do have questions, just ask. Seriously, just ask. And without further ado, if we can go to the next slide, please. Okay. Oh, right. There's a disclaimer. I forgot about that. Well, let's go back to the disclaimer real quick. Sorry. Just to note that this is not legal advice. This is a presentation of just general information. And the objective here is really to provide an overview. If you are existing clients, we're happy to have follow-up complimentary consultations with you regarding the situation for your company. And yeah, okay. On to the next one, please. All right. So what is going on with this H-1B and the $100,000 fee? And I think that, we can talk about things in general. We'll give you a little bit of an overview of the H-1B. We'll talk about some other options, but we all know that we're really here because of this proclamation made by the president that essentially tries to charge a fee for entering the United States. Now, I think it's important just to frame this discussion to give a little bit of background as to what happened and frankly to talk about the legality of what happened as well. So essentially the president is exercising a section of the law called 212F. And 212F of the Immigration and Nationality Act is really like a wartime power provision. It's essentially there and it's very wide in language and orientation, and it ostensibly gives the president the power to exclude groups of people from entering the United States if their presence is going to be detrimental to the country. It does not have to be extreme. There's no language in there like triggering what would allow for the exclusion of people to the United States. And I think that's why the administration keeps relying on it when they put forward these provisions that seem to restrict the flow of people to the country. Historically, as mentioned, this has been used during times of war. So, like during World War II, if you think it's adverse to the country to have Germans or Japanese enter the country, you block them from doing it and you do it under Section 212F. More famously, we saw it recently with the pandemic. And for those of you who remember 2020 well, and that spring, we thought the pandemic and COVID-19 was isolated to Europe at one point in China. And we said, well, why don't we just block people coming into the country from Europe or China? That was this provision of the law. It was also used in 2017 with the first Muslim ban. And in doing so, eventually, those executive orders were struck down for being discriminatory intent. Now, this situation is fascinating because the preamble to the proclamation gives a lot of cherry pick statistics around the economic impact of H-1B visa holders on the country to the point where their presence in the United States should be blocked. And they do cite some things like based in reality that I think a lot of us would find okay if they wanted it to change. For example, they talk about large technology companies laying off 15,000 people and then filing for 5,000 entry-level H-1Bs. You can see a problem there. But does that rise to the level of saying anybody with an H-1B is harming the United States and can't come into the country? It's a pretty long stretch. Now, for those of you that have gone through the green card process, that have overseen a permanent residence process, the Department of Labor has a rule that says if you've had a layoff in the area of intended employment in the last 6 months, you can't file perm. I think a lot of people would say if you wanted to put that rule in the H-1B context, that makes sense. But this is not a government of scalpels, it's a government of sledgehammers. And when they want to break something, they do it intentionally. And they want the courts, they want litigation, they want to allow themselves to clarify things and pull it back to almost make the net result more palatable because you've been struck with such a heavy-handed rule change in the beginning. And let me tell you, this one was heavy. It was a Friday night, very similar to January of 2017 when they had the first Muslim ban. It was a Friday night. It came out at 5 o'clock. We got like a little bit of a heads up about it in the afternoon, and I sent it around to like the internal like channel with all the lawyers. I was like, this cannot be real. And everybody was like, it can't be. There's got to be rumor, fake news, yada, yada. Man, was it real. And I don't even think they know what they were signing when they did it. Because like the plain language of this proclamation said, anybody outside the United States at 12:01 a.m. on Sunday, whatever the day was, cannot come into the country unless they pay this $100,000. And speaking to contacts we have at Customs and Border Protection and Department of State, they didn't know either. They had no clue either. It's like imagine your favorite sports player getting traded and finding out via tweet. Without getting a call from the GM saying, hey, you've been traded. Like, that's what it was like. Nobody had any time for planning. Nobody had time for preparation. And that goes for lawyers, companies, foreign nationals, and even the government. It was really heavy and intense. And I think we had 36 hours of helter-skelter. I will say I was incredibly proud of the firm, the reaction from the lawyers, reaching out to the clients, talking to as many people as possible. It was a lot of great work on the firm's behalf, showing up during a challenging time. But it's not a challenge that we needed. They could have done this more pragmatically. They could have done it a little bit more carefully. But when you unpack the actual rule itself, it does not make a lot of sense. So these individuals are so detrimental to the country. It's such a challenge that they can't come in. But it's okay if you give us $100,000. But it's okay if you give us $100,000. And this pay for play mechanism, I think, is like really what's at the heart of a lot of the litigation that is coming forward now. In fact, there was a big volume of litigation with the joinder situation where multiple people filed a complaint on Friday. We do expect the courts to issue a decision as to whether or not the rule will be permanently enjoined or temporarily enjoined this week. We'll have to see how it comes out. But that $100,000 is highly problematic because in addition to not telling people in the government level or companies that they would have to pay this fee, they never set up a mechanism to actually pay the fee if you wanted to. And then secondarily, as we've kind of alluded to, 212F is about the exclusion of people from the United States. Yet they set the Internal Immigration Service, CIS, up with the responsibility of actually collecting the fee. And there's an actual rule under the under the US code and under the federal code of regulations that says USCIS internal agencies that process benefits cannot charge a fee more than what is necessary to provide the benefit. So essentially like overhead and staff salaries. So $100,000 fee is certainly something that doesn't fall in line with those particular provisions. Now, the government quickly walked things back and they said, if you have an existing visa, you're not subject. If you're in the United States, you don't have to pay for it. There was some clarification. But interestingly, there is sort of these many unknowns and unintended consequences when you smack a fee like this. And in fact, if you look at all of their walkbacks and all of their provisions, the people that clearly are still subject to this are nonprofit agencies affiliated with institutes of higher education, universities, actual institutes of higher education, and hospital systems that are affiliated with institutes of higher education. So you have a preamble that talks about the H-1B's detrimental impact on the tech sector and lobs in all these employment statistics, and a proclamation that ends up only harming the heavily underserved medical communities of the United States. That's what we were dealing with here. Now, what do we think about next year's lottery? Do we think it's going to impact the lottery? I personally think that there's other changes that we're going to talk about later as it relates to the H-1B lottery that are far more likely to stick than this $100,000 fee. But over the coming weeks, a lot more of this is going to come to light. The dust will settle and we'll know where we land. My best guess is that this will probably be enjoined, as previously mentioned. And I do think that the government could come back in a couple months or a few months with a version 2.0 if they really want to push it. But the way that this particular proclamation was created, justified, executed, I don't think will become an actual provision that we have to be too mindful or concerned with. But again, lots of unknowns. And Sarah, I don't know if it's possible, but if you don't already subscribe to our blog or e-alerts, as we call it, I encourage you to do so because we do put out interpretations of these rules as soon as they are put to the public, and it's something that is a great place to get up to date information because we always relate whatever the proclamation is back to the practicalities of your particular situation, whether you're a foreign national or an employer. So I'm not sure if anybody has any questions about the proclamation itself, but you can pop those in the chat. We can try to answer them, or even the Q&A is, I guess, preferred. Okay. So whilst if we can always circle back around to this, but the short of it is it was a panic moment. It got a lot of attention. But ultimately, I think it is going to result in not much of a net impact onto the way that we process visas, and definitely not for those that have visas in their passports that are doing employer changes. It's those that are traveling abroad. It's the cap. It's these cap exempt employers, the hospitals, the universities, and stuff that we were just talking about that we do feel could be affected pending litigation and further clarification from the government. So we wanted to get the elephant in the room addressed before we got too far along. But if we go to the next slide, Katelyn is going to talk to you a little bit just about what we are seeing with the basic refresher requirements for an H-1B. We don't want to assume that everybody here has in-depth knowledge to pick up everything that I just mentioned, but hopefully this will provide some context. Katelyn, thanks for joining me on this. Sure. And yeah, take it away.
Anytime. And I would just add to what Jonathan said that we have not actually seen the $100,000 fee applied to anyone. We have not seen it asked for any of our new petitions or had anybody have difficulty traveling yet. So we're hoping that the litigation hits before we get there, but on the ground, we're not really seeing the application of the rule yet. So just to back up for anyone who's sort of brand new to the H-1Bs or has limited knowledge, as a reminder, H-1B is really one of the more common visas for US companies. It generally requires that the applicant have a bachelor's degree or higher or the equivalent of work experience. The bachelor's degree also generally has to be related to the field, to the position in some way. And the position there has to be a job offer of either part-time or full-time employment. So we see H-1Bs again, as Jonathan mentioned, for a lot of workers in the medical field, a lot of engineers, those in the STEM field, typically any bachelor level employee that has a degree in the field that's required for the position. We will get to this in more detail later with some of the newer changes, but there is a prevailing wage requirement. So the Department of Labor issues 4 different wage levels for each position. And then depending on the number of experience, that's the wage level that is generally assigned and that the employer is required to pay. H-1Bs are for employees, so not for contractors. So there's generally a W-2 relationship. And this is really the most common path that we see for our F1 students. So many of you on the call, I know we work with regularly. And so, your workers that come in on an F1 in OPT or STEM OPT work with you for a few years. Oftentimes you're entering them into the lotto, maybe more than 1 year in a row, waiting to see if they get picked. And the natural transition is generally to go from the F1 to the H-1B. Jonathan, do you want to weigh in on the new updates for the proposed rule?
So this is kind of a funky one. This came out in the Federal Register. This is the one that it's almost like, look at all this stuff going on over here, and we're gonna slip this thing under here and hope that nobody notices. Realistically, Katelyn, this new proposed H-1B stuff is really not that bad, but I don't think that the government necessarily knows what they're doing. So what the theory behind it is they feel that higher wage earners are better for the economy. And when it comes to the lottery, they don't like all these entry-level people taking up the H-1Bs because they think it is detrimental to U.S. workers that are graduating with STEM fields, particularly in the computer science areas. So their idea is, okay, let's start weighting the lottery based on wage levels. So for those of you that have been through this, and as Katelyn was alluding to, there is this mechanism when you go and do the prevailing wage, there's all these different wage levels that are set up. You have wage level 1, wage level 2, wage level 3, and wage level 4. With this proposal, if you are wage level 4, you are now going to get 4 lottery tickets. If you're wage level 3, you're going to get 3 lottery tickets. If you're wage level 2, you're going to get 2 lottery tickets. You're wage level 1, you're going to get 1 lottery ticket. So essentially, a wage level 4 person is going to have 4 times as great of a chance as being selected in the lottery as somebody that's wage level 1. And, I guess it makes sense. Who's it really going to benefit? There's a lot of people in statuses like L-1B that has a 5-year time limit on. They're not far enough along through the green card process. Their employer wants to switch them to H-1B. Those typically are higher wage earners. They're going to have an advantage. But the problem that I don't really quite get, and I don't necessarily think the government gets, Katelyn, is that within each occupational classification, there is maybe a way to have a single job fall under 2 different occupations. And understanding that certain occupations have lower wages to sort of, associated with them gives room for some creative effort. So, for example, one of the ones that's always been almost interchangeable is this concept between marketing manager and marketing research analyst. And there's a lot of language from the Department of Labor. If you're a wage level 4 market research analyst, you're meant to have managerial responsibilities, et cetera, et cetera. Well, if you go up and look up Philadelphia marketing manager, and you'll see that the level 1 wage, and this is ballpark, is around $100,000. And level 4 for marketing managers gets really expensive, $200 something thousand. If you go to market research analyst, wage level 4, which connotes having managerial responsibilities, $102,000 or something like that. So essentially, framing the job as a market research analyst and paying what amounts to be $2,000 more annually is going to give you 4 times as great of a chance of being selected as if you were in the first bucket with marketing manager under wage level 1. So part of what we're going to be doing and gearing up for this, and I think that this is really a fascinating concept, but the firm is going to be, when we reach out in January, and Katelyn's going to talk a little bit about H-1B logistics in a little bit, but we're going to start this analysis on wage classification in anticipation of this rule coming to fruition to start giving you a heads up as to what we think the lottery chances are. Well, it is going to be a matter of looking at similar occupation codes and picking the ones that are going to give us the best chance for success. And it also is this really, frankly, a change of philosophy where, historically speaking, we've always done the H-1B as our primary option, and we're going to talk about some other options a little bit later. But we've always said it's H-1B, it's H-1B, and if you don't get the H-1B, we'll look at the alternatives. I think with the Trump administration's effort to curtail the uses of the H-1B, philosophically, we're going to change. Philosophically, we might say to ourselves, what other options does this person have outside of the H-1B? Do we want to enter the lottery to create optionality, but maybe not actually execute it? And this is the fundamental change that we as counsel, to you as employers in particular, have to start thinking about, because the visa classification does not exist in a bubble. Katelyn and I make no mistakes about it. We know you don't care what alphanumeric combination of visa you get. We just know that you want to know how much is it going to cost, how long is it going to take, how hard is it, and how secure is this person's presence in the United States. Like, we get that. We get that. So, now we're starting to rethink strategies over essentially what amounts to, for most people, post-graduation visa sponsorship and what that looks like. So yeah, look, these proposed rules are pretty substantial. Again, I think good lawyering is going to quell a lot of the perceived changes to the playing field for H-1Bs, but I do think it is going to disadvantage the entry-level positions. I don't think there's much of a way around that. And I do worry what this means for the student population in the United States, which has become very, very robust. And again, I don't think any of us are going to stand here and say that processes and systems don't have room for improvement. They certainly do. They certainly do. And maybe the OPT program is flawed, but the government is heavily going after OPT and H-1B as their primary targets for employment-based immigration. And because of that, there is going to be an impact on the foreign student population and their enrollment. I don't have numbers this year for 24 versus 25, but anecdotally, it's pretty substantial. It's pretty substantial. So this, more than the $10,000 fee, is where I think our focus needs to be. It is still a notice and comment period. You can leave a notice. One little thing about rulemaking procedures in the government is they have to address all of the comments and questions. So, drowning them in question work is certainly something that we encourage. And, ultimately, I think we're going to be relatively okay, especially as it compares to other provisions that have been put out. But this is going to fundamentally change the way the lottery works. Katelyn, next slide.
Yeah, and I honestly think one of the biggest changes from a logistical standpoint is that we're going to be picking the wage codes in advance. So many of you that have been through the lottery before know that the registration side, we do sort of a behind the scenes vetting, but we are just entering the foreign nationals information and the company's information. We haven't been mentioning the job position itself or the wage level. So this is going to require much more work on the front end to evaluate what is the best strategic code to choose in order to give each person the maximum number of chances. So it's going to shift the way we sort of collect everything and do everything on the front end in that January through March timeline. I think next we wanted to talk about some of the current adjudication trends. So as I mentioned before, we have not seen much of an impact of the $100,000 fee specifically applied to our clients yet. We're sort of waiting to see how that plays out, particularly since there's no mechanism for collecting that fee yet, and also how the litigation plays out. Request for evidence, I know that sort of going into the administration, particularly with respect to the H-1Bs, we were waiting to see if there was an uptick in requests for evidence being issued on our cases. We are not really seeing that, which is good news. I would say they're coming in at about the same rate. One that we're seeing more commonly is challenging cap exemption for nonprofits and in other cap exempt institutes. So that kind of goes to Jonathan's point earlier that the government is sort of targeting that group, unfortunately. So there's just been more pushback on that. And then change to employment practices. I think we've been hearing more of that certain employers are adjusting their practices for hiring H-1B workers or visa holders in general. That kind of depends on the field itself, but we are seeing more of that as well. Anything to add on current adjudication trends, Jonathan?
Um, I know it's a little bit of an aside from what we've been talking about, but one area that we have seen really, really, really heavy adjudication trends, like almost like a 180-degree flip, is within the context of the national interest waiver. That is a green card mechanism, but it was expanded widely under the Biden administration to the point where I think a lot of fly-by-night organizations started setting up and filing these on behalf of people that were outside the United States, where they really couldn't even show that what they were doing is in the national interest. And as a result, I think the adjudication trends have flipped substantially. And I raise it here in so much as we do have to keep an eye on this. Like there is this concept within immigration of almost like de facto policy, where they don't want to come out and say it, but they start executing it through the adjudication of benefits. So will we see them start really clamping down, for example, on what specialized knowledge means in the L-1B context, because it's not really well defined? I think it's certainly something that we are like keeping a very close eye on. Typically, that's sort of the canary in the coal mine as it goes to like how a program will work. Um, for example, like one of the alternatives we're going to talk about with the H-1B is possibly using the O-1. We've seen a lot more uptick in O-1 RFEs lately. So, the unfortunate aspect of some of these adjudication trends are going to continue to get worse and harder to navigate. But it is something that we are very keenly aware of. The interesting thing is, and Katelyn stated it well, H-1B adjudication, I don't know, Katelyn's been okay. Like
Been
I mean, knock
fine.
on wood, like it has not been as bad as we had thought. But I think, you really do have to understand there's a very interesting dynamic going on at the White House between like the Stephen Miller anti-immigrant fraction of the government and the fact that this government is also really, really buddying up with a lot of industry as well. I mean, it was almost, I don't know, I don't even know how to put it. It was almost like a comedy routine if it wasn't comedy, but essentially like the week that this $100,000 proclamation came out 2 days earlier, Trump is in London with all of the business leaders from the companies that use the H-1B program the most, touting our investment in UK AI as a means of generating growth in the United States. And then those are the very companies that became the target of a proclamation the next day. Now, whether or not they got a lot of pushback from those particular countries, and that's where we started seeing the clarifying FAQs come out Saturday, your guess is as good as mine. But I think like the ability of this administration to present one way to one audience and another way to another is something that helped galvanize their power, but also is politically awkward when you have something like this changing with the H-1B. Unfortunately, when Elon Musk like left Doge, I think that influence on keeping the H-1B static diminished, and the trends are definitely towards restriction on visas and visa processing. So. Yeah, tough situation on terms of adjudication trends.
Yeah, and going along with some of the specific changes to the visa processing, so this affects foreign nationals more in particular than employers, but it's something that you may be getting questions about, and it may sort of interrupt the flow, especially of business-related travel. So there used to be a process called the interview waiver. We commonly called it the mail-in as well, where to renew your visa, especially if you've had one before, there was an option to drop off the the application packet and sort of process your whole visa by mail in your home country. That has been eliminated. So everyone is now required to go to an interview. There's no sort of mechanism for skipping the interview portion, even for renewals. And sort of more significantly, the recent change from a few weeks ago is that foreign nationals are required to travel to their home country or their country of last residence in order to apply for a visa. So this is particularly affecting Indian nationals significantly because India is historically backed up in getting the visa appointments. And it also affects our Australian clients a lot because they were very used to going to London or Barbados or a closer consulate for visa processing, and now everyone is sort of having to go home for a few weeks. It does require more advanced planning because appointments are getting further and further backlogged with this change. And so it's just something to be aware of. Anybody who's going to need to get a new visa, they're going to have to make plans for that further in advance. If any of your employees are going to need to do business travel, you want to make sure that they have a plan for that lined up. So that's just sort of affecting the flow of visa processing that we're seeing.
Yeah, I find this really, really, really challenging. From an efficiency perspective, from an environmental perspective. I mean, the thought of an Australian having to travel from New York to Sydney for a visa process instead of popping to
Every 2 years.
Barbados.
Yeah.
Oh, it's
Yeah.
like mind-boggling. It really
Yeah.
is that this is the direction they're going. And again, this is like completely different from the previous administration that actually said, we know some places are backed up. We know that some wait times are harder. You can pretty much go wherever you want. There are some examples where you can still do mail-in filings, like specifically for visitor renewals. You can do that for B1, B2s. But Katelyn's right. I mean, as far as employment goes, we have not seen any clarification come out. Now, the funny thing about that particular preamble was that the language in that exact order was very vague. It didn't feel like somebody with a law degree wrote it. Like one of the things, Katelyn, that I found challenging is that it says foreign nationals should process back in their home country or place of residence, not must. So they left this window. And then they also put in this whole like caveat about industry exemptions. But they've yet to suggest what industries might be exempt from some of these sort of requirements or how that's going to play out. So, again, I think we need a lot more information, but it is problematic. And there's a great question here on the chat. What happens if there's no embassy in the employee's country of residence like this? Well, they did actually do a decent job of providing locations where you can actually go. So, for example, like Ukrainian individuals will process in Poland for their visas. Russians can go to
Venezuela,
Kazakhstan.
specifically Bogota. So for that question, yeah. So they do have backups for everyone.
Yeah, so I do think it's going to need a lot of planning. I think, for those individuals that were thinking about going to their home countries around the holidays and need to get a visa appointment to come back in, that might not be so easy. And actually, that was September 8th. Man, it feels like a long time ago.
I know.
I'm going to put a link to our post on this in the chat just so you can look at it in your own time. Well, an absolutely challenging situation as far as that goes. So good question, Antonio. There are places where people can go. It's just not necessarily going to be convenient.
And I will say, I know, Jonathan, you mentioned the language leaves a little bit of wiggle room, but I do believe we've had people that immediately after the change proceeded with their appointment elsewhere, so not in their home country, and were denied, unfortunately. So it is risky to sort of attempt to get around that by processing in another country because, they might just be denied at a greater rate.
I honestly don't think they're making any exemptions. It is worth noting that if you have a pre-existing appointment prior to September 8th, they are allowing you to keep them and adjudicate them. It is the newer ones. Kayla's right. Like right after that came out, a few consulates and embassies were not allowing anybody to apply, even if they had a pre-existing appointment. That got walked back in most locations. But again, it's not the easiest thing to advise on or give guidance on. So yeah, challenge, definitely logistically challenged on that particular one. All right. So, as we kind of mentioned to a little bit earlier, realistically speaking, we're not thinking H-1B first. Mentally, we're changing our perspective. We're talking about, Can we activate the J1 researcher? Can we do L1 intercompany transferees? Can we do more STEM OPT, O1 extraordinary ability, etc.? And Katelyn, can you talk to me a little bit about how some of your, and we'll go through some of these obviously, but can you talk a little bit about how some of your conversations have been going with employers, what they're saying, what the demand is? And, as far as the audience goes today, you can feel free to type in the chat some of your own feelings on this, but I don't know. I mean, I hate to say this is the end of the H1 program, but man, sure is getting a lot trickier to use. So what are you hearing,
Yeah,
Caitlin?
I think everyone's really looking for alternatives across the board. And I have heard that some large employers are trying to avoid hiring H-1Bs, period, at this point. So that's sort of what we're seeing. We're definitely talking about more options for people where that is an option. Many of our clients have the option of the L1 if they have foreign offices. So, where they might choose to try the H1 if the L1 is an option, even if that means delaying the offer for a year. That's something that people are looking into. I know we've also talked recently, Mexican and Canadian nationals often have the TN visa option, especially depending on what category of occupation that falls into, where in the past, the H-1B would have been preferable. I think individuals are leaning more heavily on the TN right now. And then also it seems that we're getting a lot of questions asking about permanent residency. So, kind of just wanting to skip to that next step, maybe a little bit more quickly than before to get out of the non-immigrant visa chaos altogether. That's sort of what we're seeing from people.
And I do want to highlight that's actually an interesting point. When the insecurity that foreign nationals have right now, willing employers who are opening the conversation about green card processing, taking a look at these kinds of things. That is something that is, um, you know, can go a long way from the HR perspective of keeping people engaged and working hard. I can only imagine the fear and the distraction that, worrying about your visa and long-term prospects in the United States has. So there are some things that employers can do to really, tell people like, look, we don't have all the answers, but we're willing to put the effort in for you. Now, obviously, there's a cost benefit side to that, and it's not for everybody, it's not for every situation, but we are seeing HR teams in particular trying to engage with the most vulnerable of their foreign national population. And this goes beyond the H-1B. We're talking about the ending of TPS or the DACA program or some of these humanitarian paroles where people will be left without status. And getting around that and strategizing is important. I mean, people don't necessarily recognize it, but with the end of all these temporary protective status visa classifications, we do see upwards of 500,000 currently legal and employment authorized individuals in the United States having to depart. That is a huge, huge amount. If there was one company large enough in the United States to say we're laying off 500,000 people, the economy would be actually absolutely tanked. But because it is part of this wider agenda, it's not even registering people or moving the needle. And like that lack of effort and understanding around some of these provisions is, I think, what really does cause future challenges in giving more bandwidth to the organization. And therefore, to stress the importance of those notice and comments on the wage levels, like make a comment. Great question here. Is the $100,000 fee still applicable for H-1B exempt nonprofit? Technically, at this moment, our interpretation is that yes, it is still there. Now, I think Katelyn was telling me that she's filed quite a few of these with the employer's permission, and so far none of them have been returned, which is good. It's certainly something that we are keeping a close eye on. One of these alternatives that I really do want to highlight is this J1 researcher thing. Now this is an interesting one because essentially, Katelyn, the J1 researcher program was like historically reserved for universities, right?
Right.
And you could get up to 5 years as long as you're working in your field of endeavor. In 23, it really came to fruition from the previous administration that this is something they want to encourage and allow to occur outside of the incubator university setting. as such, they essentially allowed for universities and agencies to start issuing their own J1s. Now, this is not a panacea. It's certainly not a cure-all, but it does give us another sort of opportunity to engage in keeping a foreign national employee within the United States. And the trick here with this J1 researcher program is that the job has to at least have some research component to it, and the individual has to have at least a bachelor's degree in an IT related STEM type of field, or anything really STEM will work. It can be research on biochemistry, it can be quantum logarithm creation, whatever it is, those are fine. But we really do encourage you to take a look at it. Now, what's fascinating is people used to always say, well, I don't want the J1 because it has a 2-year home residency requirement. One of the greatest gifts that the Biden administration did give the immigration world is that they changed the skills list. And the skills list is a book of each country, the skills that they need for their country. And if it's listed on the skills list, the individual has to go home for 2 years. As you can imagine, getting a J1 for somebody from an Indian, who happens to be of Indian, where, they really don't have the optionality of leaving the country. They are doing STEM and research work. This could be a really great opportunity and something that we will definitely be using more into the future. Before I hand it over for Katelyn to talk about STEM OPT, which I think is important, I do want to make a note to intercompany transferee. Intercompany transferee is really one of those visa classifications that is special because it doesn't have numerical limitations. All you have to do is go abroad for a year, work for a related entity in a managerial or supervisory knowledge position, and you'll be able to enter the United States. A lot of companies are saying, you know what, instead of doing our training here in the US and relying on the H-1B lottery, we're going to send this individual abroad and have them work not only on a specific field to hone their skills, whether they be managerial or individual contributor, but essentially to trigger that L visa optionality down the road. Avoid the H-1B completely and benefit the company on a sort of global branded communication coming out of the pandemic. So we have been able to really push and work with employers to set up intercompany portals that might turn out to be more advantageous than the H-1B itself. As a segue into the STEM OPT extension, let me ask this question that came through the chat. We have an employee on F1 STEM OPT. He's scheduled to return home to India for a couple of weeks. Can you clarify the risk and management associated with it? Well, I mean, Katelyn, it's under Q&A. That is a call that we get all the time, and maybe you can talk about it.
So we haven't seen any changes to travel for students or anyone with STEM OPT. Anything different than before. Jonathan, I don't know if you've seen anything on your team, but that's pretty much business as usual right now. So not anticipating any issues there. So that also sort of might be something that happens. Many employers apply for the H-1B cap starting in the first year of someone's OPT. For those with STEM, of course, they're able to take advantage of that 2-year extension with degrees in the STEM field. So it might just be a matter of keeping those individuals on their OPT a bit longer, seeing what sort of shakes out with the H-1B program over the next year or two, particularly if this wage level change sticks and the wage level 1s and 2s aren't selected this year. So that's sort of always an option. We have another.
Yeah, this one is a good question here. It says, what level of experience do they consider entry level? I have 2 F1 students that want to enter the lottery. They're both individuals who had 2 years of experience in India post-bac. They came to the US, etc. So it's not by the foreign nationals qualifications that dictates the wage level. It's the employer requirements. So if you require an advanced degree, that pushes it up a wage level. If you have experience associated with it, that pushes up a wage level. The foreign national has to qualify for the job, of course, but it's not the foreign national's credentials or background or experience that dictates the wage level. It is all about what you as the employer require. So that is definitely something to be mindful of. We had another question, I think, in the chat. Let me see if I can grab this.
Mm-hmm.
H-1B was filed in last week of July. The following month, I received an RFE. That's one of those individual ones we'd have to look at. It's not really something that would be applicable here, but the newly announced H-1B rule will not impact this particular aspect or filing. At least we don't think so at this particular time.
And
Can you
that's
talk a
because it
little
was
bit more
filed
about?
before September 21st.
Yes. Well, it
Yeah,
looks like it says it was filed in July. Um,
right.
okay, Katelyn, you want to talk a little bit about leveraging in the OPT, CPT kind of thing? And there's
In
a question
terms
that
of,
just came about that.
oh,
How you're
go
seeing it
back. Yeah.
functioning, what you're worried about, your concerns, that kind of thing.
F1. Yes. So I don't know if we're looking at the same question, but yes. So we have had.
This was off. This was off question. This is just my question. I apologize.
Okay. No, because we got a CPT question at the same time.
Yeah.
Yeah. So we have certainly had plenty of clients go back to school, especially if they're not selected in the lotto and they're sort of out of options. So day one CPT can be a really good option. That involves basically transferring, or not transferring, but enrolling in a new program and then taking advantage of the CPT offering they have to begin work authorization essentially when the program starts. So, I mean, the downside of that, of course, is that the foreign national would have to be going to school at the same time as they're working and completing all their coursework as required, but it does allow sort of a steady way to continue with that work authorization. It can be done for this question from Antonio. It can be done in the U.S. generally speaking through a change of status if there's no obstacles to filing a change of status. So you don't necessarily need to get the visa stamp depending on particular situations, but that is something that's unfortunately pretty common. It's common both with those who aren't selected in the lottery, and then also sometimes when there's a gap between the H-1B and the perm, and that needs to be filled in. That's something that we see as well.
Yeah, I think that that's a very good point. I also want to stress that unfortunately the government start sending FDNS officers out to check on STEM OPT programs and whether or not you're actually engaging in the training plan that was put forth in the filing that went to the school. This is the first time that we've seen these kinds of things. So, a lot of times the foreign nationals will have employers fit. The employer will have the foreign national fill out their own 983 training plan. Be careful because they are coming, they are looking at this. In the same respect, we're also seeing an uptick in ICE activity in correspondence to some of these rollouts in national cities involving the National Guard, et cetera, et cetera. For example, Washington, D.C. was very heavily hit a few weeks ago with a lot of notice of inspection. That's essentially them opening an investigation into an employer for their I-9 practices. You couple this with the Department of Labor now having some oversight in the enforcement realm of visa processing, and we will see a huge uptick in ostensibly what will be worksite enforcement moving forward. So, historically, everybody with the STEM OPT is like, okay, sign it, it's all right, it's all good. And, for really as long as that program's been in place, I've never seen that come back to anybody. But I think now they are going to be using it as a tool to provide that sort of de facto denial or really effectuate the individuals that are here specifically in post completion training under the STEM exemption. So keep a close eye on that. What do you think about extraordinary ability, Katelyn? Can you make me extraordinary? I'm feeling pretty extraordinary today, but can you make me extraordinary?
Right. So this is one, again, it's used as a backup as well or as an alternative option. So generally they're looking for someone who's accomplished in their field. So certainly publications help, patents help, any other showing of extraordinary ability or merit beyond what would generally be expected. So that's not a visa for everyone, certainly. But depending on, who the client is, sometimes a case can be made, even in very specific fields. We've done some really interesting fields that you wouldn't necessarily think of. So that's always something worth looking into. I don't know, Jonathan, are you seeing increased scrutiny in those yet, or not so much?
I am seeing an uptick in requests for evidence on the O1 front. I wonder whether or not it's more with and I've always thought there's not much of a difference in adjudication trends, but we do see it more with the premium unit than the regular unit right now. Typically, it hasn't changed the overall approvability faction. The cases are still getting approved, but there's definitely been an uptick in adjudication and enforcement, issuance of requests for evidence as it relates to the O1. So yeah, it's not the easiest, but the cool thing about the O1 and why I really like it is we know the criteria. A lot of them were alluded to by Katelyn. So if you don't have something like a publication in major media, like you can work towards it and you can strengthen your case. We are trying to engage students earlier in their OPT journey to talk about building up profiles for O1. So it is definitely something that we're like very, very, very conscientious of. But yeah, it's tricky. It's tricky. Right on. So the other visa classifications that we have listed here are more for those free trade visas, the more that are like really in on some bilateral agreement or treaty of friendship that allows for visas. We do want to highlight, if you're looking for talent, the TN for Mexico and Canada, notwithstanding some negotiations that are going to be starting, is very, very, very solid. The E visa, particularly the E3 for Australians, is solid. The H-1B one for Singapore and Chilean nationals is also very, very, very solid at this particular juncture. Katelyn, I know we're kind of getting up on time, but one of the interesting correlations of this, Antonio, could a change of status be denied? Things can be denied, of course. I mean, there's no guarantee when it comes to immigration. One of the things that we alluded to was maybe starting the green card sooner. And I think one of the corollary effects of the Trump administration cracking down on immigration is that there's going to be less people applying for green cards. And if there's less people applying for green cards, the wait time for adjudication, for the visa bulletin, that's all going to get shorter. Are you seeing the PERM process or NIW successfully be an alternative to the H-1B?
So I think that for the perm, again, you mentioned the wait time, but it is around 2 years or so, 2.5 years maybe, start to finish. So what we are seeing is certainly employers looking into that sooner. So previously, a common path we would see is the employer petitions for an H-1B, the foreign national gets the H-1B. At least 1 year later, sometimes up to 3 years later, is when they would think about the green card process. Now we're seeing some employers thinking about the green card process simultaneously with the lottery, or certainly much sooner. We are still having clients consider the national interest waiver sometimes in conjunction with perm. If you want to be really aggressive, you can run the two simultaneously. But that is something that is still being looked into. That's not an immediate solution either, just because of the priority date backlog. But I think that is and will be much more difficult. We had a good year or two of those sailing through, and that being a really healthy alternative or a near-term solution for H-1B holders or alternatives to the H-1B. I don't think that will continue that way, as you mentioned earlier, but it's something to think about.
Well, great. Katelyn, that was a rip-roaring tour through the current state of immigration. I appreciate you joining me. Does anybody have any questions with the last few minutes that we have? All right. Well, listen, I think we can call it with a few minutes left. We will be endeavoring to send out a recording of this particular meeting, at least the transcript. Please feel free to reach out to the firm if you have any questions, comments, concerns around the H-1B or other visas that we discussed today. Katelyn, do you have any final words?
No, just what you said. I know we've been having these strategy calls with a number of clients, but we're always happy to do that, even looking into this year's lotto, next year's lotto, and the future. So don't hesitate to reach out.
Well, thank you. And hopefully we won't have a need to have such urgent communication like this again in the near term. But when there are changes, we will certainly be diagnosing and putting our advice and guidance through the Q&A. And more specifically, if there is something as seismic as this particular situation in the H-1B, we will open up future town halls and meetings like this. Thank you, everybody. Have a great rest of your day, and we'll see you soon.